This is Barry Zalma on insurance. This date we should speak about what to do to help the U.S. government or the state government to work to defeat insurance fraud. This can be done by using the qui tam statutes and becoming a whistleblower. If an individual, whether in the insurance business or not, has knowledge that a false claim was submitted to the government or to an insurer in those states where there is a state qui tam action, that person can elect to become a whistleblower and retain an attorney who will draft a complaint and a disclosure statement. The whistleblower will file these two documents under seal in a U.S. District Court and send copies to the U.S. Department of Justice. After the complaint is filed, the Justice Department has 60 days to investigate the allegations and determine whether it will join the lawsuit. If the Justice Department does join the lawsuit, it has the primary responsibility for prosecuting the case and can limit the whistleblower's participation in the action. If the qui tam action is successful, the whistleblower's share of the recovery will range from 15 to 30%, depending on the extent of the individual's investigation. The trial judge normally determines the appropriate percentage. If the department decides not to participate, the whistleblower has the right to continue to pursue the claim on behalf of the U.S. and will receive a higher portion of any recovery received. The False Claims Act states that any person can file a qui tam action as long as they have direct and independent knowledge of the fraud, and this knowledge was not obtained from a public disclosure. The definition of person includes not only individuals but also businesses and state or local government entities. The most common plaintiff in qui tam actions are employees of government contractors, healthcare organizations, and local, state, or federal governments. The question that is raised every time a qui tam action is filed is why the U.S. and its various federal police entities and the U.S. Department of Justice did not bring the action itself and act proactively to defeat fraud against the government. Every 2 years, politicians claim they will find various projects and fund them by eliminating fraud and abuse, only to do little or nothing to defeat fraud or abuse. Obamacare is a perfect example where the funds to run the anti-fraud work was reduced every year after Obamacare was enacted. The qui tam statutes make it expensive to an employer to retaliate against the employee whistleblower. If it can be proved that an employer has taken any adverse action against the employee may seek compensation from the employer. Compensation includes reinstatement of the same seniority status, an award of 2 times the employee's back pay plus interest, and any other special damages the employee also may receive reimbursement for all litigation costs, including attorney's fees. Besides the False Claims Act, there are a number of other statutes that offer protection for whistleblowers. Such statutes include the Civil Service Reform Act, 5 U.S.C. 2302, the Fair Labor Standards Act, 29 U.S.C. 215, the Occupational Safety and Health Act, OSHA, 29 U.S.C. 660, the Employee Retirement Income Security Act, ERISA, 29 U.S.C. 1132, Title VII, Equal Employment Opportunities, 42 U.S.C. 2000E, Age Discrimination in Employment Act, 29 U.S.C. 623, the Civil Rights Claims, 42 U.S.C. 1983, the National Labor Relations Act, 29 U.S.C. 158, the Federal Whistleblower Statute for Employees of Defense Contractors, 10 U.S.C. 2409, the Federal Deposit Insurance Act, Financial Institution Reform, Recovery, and Enforcement Act of 1989, 12 U.S.C. 1831J. Almost every state has some form of legislation protecting whistleblowers. For example, California Government Code Section 12650 et sec. Protects California whistleblowers. Many state statutes specifically describe how a report must be filed and provide the names of the agencies that must receive the report. Some states also may require that the employee's first report be directed to the employer, so the employer has an opportunity to correct the circumstances that may have caused a potential violation. Courts also may dismiss a qui tam suit if good cause is shown. For example, one court stated, "We have reviewed the statutory language, the meaning of good cause in other contexts, the purpose of the False Claims Act, federal cases interpreting a similar federal statute, and the legislative history of the False Claims Act. We conclude good cause for dismissal of a qui tam action filed on behalf of a political subdivision exists where the dismissal is rationally related to a legitimate government purpose and not arbitrary, capricious, made in bad faith, based on improper or illegal motives, founded on an inadequate investigation, or pretextual. In exercising its discretion, the trial court may consider any matter relevant to the issue, including the relative merits of the action, the interests of the qui tam plaintiff, the purpose underlying the False Claims Act, and the potential waste of government resources. This is a case called Laraway v. Sutro and Company, a 2002 decision of the California Court of Appeal. Since the revitalization of the Federal False Claims Act in 1986, individuals may use the qui tam privileges to file civil suits on behalf of the government against employers suspected of fraud. For example, Maxim Healthcare Services, a leading provider of home health services throughout the United States, agreed to pay a record $150 million in civil and criminal damages to settle charges that it engaged in a nationwide scheme to defraud Medicaid and other federal programs. The details of the settlement with Maxim were announced in September of 2011. The criminal complaint accused Maxim of submitting more than $61 million in fraudulent billings over a 6-year period to Medicaid and to the Veterans Administration for services did not perform or that were not reimbursable under the program's guidelines. The case came to the attention of authorities when Richard West, a Medicaid beneficiary in New Jersey, called the Department of Health and Human Services to complain about billing irregularities in his Medicaid statements. That one phone call helped launch the government's investigation and led to a whistleblower's complaint later filed by West. According to the settlement arrangements released by the U.S. Attorney's Office, Maxim entered into a deferred prosecution agreement that allows the company to avoid a health care fraud conviction, a criminal conviction, if the company took a series of steps within the next 2 years to reform its corporate practices and strengthen compliance monitoring. In addition, Maxim will pay out approximately $70 million in civil damages to the federal government and another $60 million in civil penalties that will be divided between 42 states. Maxim will also pay a $20 million criminal penalty. According to the prosecutors, the whistleblower by statute will share in the recovery made by the government. The Justice Department stepped up its pursuit of fraud cases under the Obama administration, and since January of 2009, more than $8 billion had been recovered. Since that time, the Justice Department has been prosecuting doctors and healthcare providers with alacrity and have collected much more in billions of dollars for the frauds perpetrated by these insurance fraud and government fraud perpetrators. For example, on June 28, 2018, the Justice Department reported that Attorney General Jeff Sessions and the Department of Health and Human Services Secretary Alex M. Azar III announced the largest ever healthcare fraud enforcement action involving 601 charged defendants across 58 federal districts, including 165 doctors, nurses, and other licensed medical professionals, for their alleged participation in healthcare fraud schemes involving more than $2 billion in false billings. Of those charged, 162 defendants, including 76 doctors, were charged for their roles in prescribing and distributing opioids and other dangerous narcotics. 30 state Medicaid fraud control units also participated in the arrests, and in addition, HHS announced that from July of 2017 to the present date of this report, it has excluded 2,700 individuals from participation in Medicare, Medicaid, and all other federal health care programs, which included 587 providers excluded from conduct related to opioid diversion and abuse. The enforcement actions were led and coordinated by various federal and state criminal agencies, and the charges are voluminous and eventually resulted in convictions. For example, as will be reported in the October 1, 2021 issue of Zalma's Insurance Fraud Letter, Health Plan Intermediaries Holding LLC agreed to pay $2 million to resolve allegations that it and its third-party agencies knowingly marketed and sold insurance policies that were being misrepresented as Affordable Care Act compliant to consumers, misleading consumers with limited knowledge and large out-of-pocket costs. The settlement also resolved allegations that health plan intermediaries holdings illegally increased the cost of coverage to policyholders to cover their broker fees, among other fees. In addition to the $2 million settlement payment paid to the state into its general fund to benefit consumers, taxpayers, and residents. The company also agreed to reform several of its business practices, including a change in its sales and marketing practices. A Georgia genetic testing laboratory also agreed to pay up to $200,000 to resolve a claim of anti-kickback violations. And a South Hills, Pennsylvania pharmacist pled guilty to healthcare fraud conspiracy by fraudulently obtaining controlled substances and misbranding drugs. And a local provider agreed to settle allegations of improper billing for electroacupuncture devices in violation of the False Claims Act, while an Orlando cardiologist, an individual cardiologist, Dr. Ashish Paul, agreed to pay $6.75 million to resolve allegations of False Claims Act violations and avoid jail, while an ophthalmologist in New York, Dr. Amit Goyal, pled guilty to a 7-year healthcare fraud scheme and to defrauding the government and the SBA, while Dr. Francisco Patino of Wayne County, a pain doctor, was convicted after trial of over $100 million healthcare fraud scheme. These are just a few of what's happened in the last 15 days. More are coming. More are being arrested, tried, and convicted. And many, if not most, are being brought to the attention of the government by a whistleblower. So it's incumbent on everyone who learns about fraud to consider becoming a whistleblower, not for the profit you may gain from it, but to help the government. If you found this video to be interesting or useful to you and your colleagues, please pass it on. It's free. And please also subscribe to my YouTube channel, my Rumble channel. Click the like button and the Rumble buttons. It'll help. And please also subscribe to my blog and my Substack publication. Thank you for your attention.